When a person passes away, his or her assets must be distributed to the rightful heirs and/or beneficiaries. Probate is the judicial or court mechanism by which this occurs. In some cases, disputes arise that lead to litigation. A probate litigation attorney helps individuals, heirs, beneficiaries, executors, and trustees navigate the litigation process to secure the best result. Probate litigation refers to the legal proceedings associated with contesting a will, disputing a trust, seeking redress for a breach of fiduciary duty, quieting title to a property, securing property that was wrongfully taken, addressing incapacity or undue influence issues, or tackling a tortious interference with an expected inheritance claim. The terms attorney and lawyer are interchangeable. However, note that there is a difference between a probate litigation attorney and an estate planning attorney. A probate litigation attorney is a trial lawyer, familiar with wills, trusts, and estate planning issues and the court processes involved in contesting a will, disputing a trust, etc. While an estate planning attorney typically is an expert in creating estate plans, trusts, and last wills and testaments, routinely they are not familiar with and do not get involved in trials and trial preparation issues that a probate litigation attorney handles regularly. You should consult a probate litigation attorney anytime you question what a loved one is doing with their estate, or if you're an executor or trustee being asked about how you are administering a will, estate, trust, or trust estate. A probate litigation attorney is typically called upon to resolve common will, trust, and estate disputes, including frequently, especially with elderly or impaired loved ones, a will, trust, or estate plan is changed under suspicious circumstances. For example, in the hospital after a stroke, or to make an unnatural person a beneficiary, for example, a caregiver. Sometimes a will, trust, or estate plan may contain mistakes or omissions that need to be addressed. In any of these cases, a will or trust will need to be legally contested or disputed in court, or court guidance will be needed to resolve the mistake or omission. Undue influence refers to a situation in which a person in a position of power takes advantage of another individual. It is one of the most common reasons for contesting a will or trust. Often an undue influence claim will coincide with a claim that the decedent did not have sufficient mental capacity, and as a result of that incapacity was susceptible to undue influence. If one or more heirs or beneficiaries believe that someone overcame the decedent's own desires for someone else's benefit, the heir or beneficiary may challenge the validity of the document or the distribution, and seek to have the assets of the estate distributed in accordance with what the court confirms to have been the decedent's true wishes. As part of undue influence, a probate litigation attorney may challenge the validity of a will or trust if an heir or beneficiary believes that the decedent lacked the mental capacity to make sound judgments about how their assets should be distributed. An executor is a fiduciary, often an individual family member appointed to fulfill the requirements of a will. A trustee operates in a similar capacity. They too are a fiduciary, appointed to fulfill the requirements of a trust. If for whatever reason they don't act in accord with the decedent's instructions or their obligations under the law, then probate litigation is the tool to seek suspension or removal of the fiduciary, appointment of a responsible fiduciary, and recovery of damages from the fiduciary breach. Probate litigation hearings and trials typically occur in the county probate court where the decedent died, in the case of a will dispute, or any county in which the trust is being administered. For this reason, it is important that the probate litigation attorney be familiar with the county probate court in which the case is taking place. So, if the decedent lived in Los Angeles and the litigation is taking place in Los Angeles Superior Court, then it's probably best to retain a Los Angeles probate attorney who's familiar with that court. If the decedent lived in Miami, then it's probably best to retain an attorney familiar with the Miami-Dade County probate courts. At RMO Lawyers, we protect people like you every day. For a free consultation, just email us at hello@rmolawyers.com. Thanks for watching.